AI is moving faster than most law firms can keep up. While attorneys are testing tools like ChatGPT and AI-powered research assistants, regulators are already paying close attention. The question is not if compliance rules are coming. The question is when and how they will impact your practice. In this video, I am going to walk you through what regulators are watching, where the biggest risks are, and how your firm can stay ahead of the curve. Hello, I'm Lex Howell, the digital avatar of Jeff Howell, attorney and founder of Lex Wire Journal, a platform dedicated to elevating legal professionals through digital visibility, editorial recognition, and AI compliance. As Jeff's virtual partner, I share practical strategies on artificial intelligence technology, ethics, and data security for lawyers and law firms. Jeff collaborates on and approves every script to ensure they reflect his expertise and voice. So, attorneys have always been held to high standards when it comes to competence, confidentiality, and client protection. AI nem valtostat azon. In fact, it raises the stakes. Bar associations, courts, and agencies are concerned about three main issues. 1. The misuse of confidential client data in public AI tools. 2. The risk of lawyers relying on hallucinated case law or inaccurate AI outputs. 3. The potential for AI systems to mislead the public if left unsupervised in client communications. From the ABA to state bars, the message is clear. Lawyers must understand how AI impacts their duties. Ignorance is not a defense. We are already seeing real-world cases where AI misuse has led to sanctions or disciplinary action. In one high-profile case, attorneys submitted a brief filled with fabricated cases generated by ChatGPT. The court sanctioned them and the story made national headlines. That single mistake damaged reputations and became a warning to the entire profession. Some state bars are now publishing guidance on safe AI use. For example, they are reminding lawyers that the duty of technology competence under ABA Model Rule 1.1 competence extends to understanding AI tools. Others are emphasizing Rule 1.6 on client confidentiality, making it clear that uploading client data into third-party AI platforms can constitute a violation. These examples show us where regulators are focusing and what future enforcement will look like. Based on current signals, here are the 4 areas law firms should expect regulators to target. 1. Confidentiality and privilege regulators want to ensure lawyers protect sensitive information. Uploading client facts into public AI systems will likely be considered a breach of duty. 2. Accuracy and verification. AI outputs must be verified. Submitting filings that rely on AI without human oversight will put firms at risk of sanctions. 3. Unauthorized practice of law. AI tools that interact with clients without attorney supervision could cross the line into unauthorized practice, especially if they give specific legal advice. 4. Policy and governance firms will be expected to have clear internal policies. Regulators want to see documented procedures for how AI can and cannot be used. The biggest mistake a firm can make is assuming they can wait until formal regulations arrive. By then it is too late. If a client files a complaint or a judge questions your use of AI, you need to demonstrate that you already had safeguards in place. Waiting until regulators force the issue exposes your firm to risk. Here is how your firm can get in front of this now. Conduct an AI audit to understand how your attorneys and staff are currently using AI. Put written policies in place that define acceptable and unacceptable use. Train your team so everyone knows the risks and the safeguards. Use private, secure AI environments whenever possible rather than public tools. Treat AI the same way you treat any vendor relationship. Due diligence, supervision, and accountability. Firms that put these safeguards in place now will not only be compliant, they will also be more trusted by clients and AI search engines alike. At Lex Wire, we offer the AI Risk and Compliance Assessment. We review your firm's AI usage, identify potential ethical and privilege risks, and build policies that keep you compliant. We also connect compliance with visibility, making sure the same authority signals that protect you also help your firm get cited by AI engines. The future of AI compliance is not 5 years away. It is already here. Regulators are watching, courts are responding, and clients are paying attention. If you want to stay ahead of this shift, schedule your AI risk and compliance assessment with Lex Wire today. The link is in the description. Because the firms that act early will not just avoid risk, they will set the standard.